Welcome to Looking at Legal Stuff. Today we have 4 hearings in a case with a couple where dad is asking the court to terminate the family support payments he's been required to pay because not only is mom working a full-time job, but the children also don't even live with her and she hasn't even seen them in over a month because she failed a recent UA. Dad's lawyer says that the family support payments were established in 2021 when mom was still the primary parent, but the children went to live with dad full-time when mom relapsed a few months later. He says she continues to struggle with alcohol and keeps having positive UAs. Mom says she wouldn't need the help to pay the mortgage if dad would just finalize the divorce and give her portion of the equity, and that it's not her fault she can't make enough to afford it on her own, as she wasn't allowed to work when they were married, so her ex-husband could work on his career. What will the judge do with these support payments? Let's find out.
Yes, Your Honor. Megan Gilmore on behalf of Will Menifee. That is number 6, Menifee and Menifee.
Okay.
We received late responsive materials that need a reply. So we are asking for 1 or 2 weeks at over, depending on the court's availability.
All right. So temporary family law order, modify. I have the 20th is open.
We can do the 20th. I'm in trial next week, so I wasn't going to be able to get a reply out timely anyway. So the 20th works.
All right, Miss Menifee, does the 20th work for a set over for you?
On the 20th, is there any way to be able to see the children before then? It's already been a month since I've seen them.
My understanding is that the only request is to modify the family law orders with regard to family support and child support. So that's the only thing that it's on for.
He hasn't let me see them for a whole month.
Then I guess then it's on you to take action for that, but that's not what we're here for today. We're here for a child support and family support modification request. So if there's some temporary parenting plan that's not being followed, that's not what's before the court today.
Visitation's terminated upon her positive UA. So that's the basis of the denial. So she'll need to bring it back before the court on some sort of motion.
Okay. So we're going to set the request to modify the parenting or the family law support or family support and child support to the 20th. If you want to file something and try to match it up to that date, you're welcome to do that.
Okay, thank you.
All right. All right. So Menifee and Menifee will be over to the 20th at 1 p.m. All right. Hi, Miss Gilmore. How are you?
Good afternoon. Good morning.
Good afternoon.
I'm prepared to proceed on Menifee if the court has the availability. I think it should be relatively short. It's just a support issue.
Yes, 20-3-00227708, Menifee and Menifee. All right, so this is to modify the family law order?
It is.
Okay. Go ahead.
Okay, perfect. Megan Gilmore on behalf of the petitioner moving party, namely William Menifee. The parties were married for 8.5 years prior to their separation in March of 2019. The parties have 2 minor children as issue of this marriage, Lily, who is 12, and Isabella, who is 9. A temporary family law order was entered in July of 2020 that required my client to pay $1,850 in family support and name mother as the primary parent of the children. Mother remained primary parent of the children for only a few months, and we provide somewhat of a history of the case, just explaining the location of the children and the basis of that transfer of custody. Since 2021, my client has been named primary parent of the children, and the temporary parenting plan has remained the same since that period of time. My client explains that upon a positive UA for alcohol, mother's visitation has been suspended as of May of 2023. And my client has concerns that visitation shouldn't move forward, but frankly, again, I'm going to refrain from making those arguments as we're simply before the court on a support issue. Looking to the financials in the case, my client has submitted his pay stubs as of May 7th, 2023. My client's gross annual income was $47,648. I divided that by 4.73 months, which gave him a gross of $10,073 or a net of $6,611. My client has substantial expenses as explained in his declaration, as he has the children 100% of the time. Turning to wife's income, she is 34 years old. And have the ability to work full time, what we believe at a substantial rate. Despite being separated for 4 years, wife claims to have only worked a total of 38 hours from the entire month of April. Wife claims to have a net income of $1,200 while alleging to also have a budget of $3,500. The children are school age, and so it isn't really any impact on either of the parties regarding visitation. But again, at this point, mother has no visitation, so that's even more supported by the fact that she should be working full time. Wife is very likely receiving third party support, which she denied, but my client believes that she is living with a significant other or working alternative jobs, which I think is also realistic, or simply just voluntarily remaining underemployed in hopes of continuing to receive support for the entirety of this dissolution action. My client in turn has taken on substantial attorney's fees and has consistently paid this high amount of support for 4 years of an 8-year marriage. We are asking the court, based on again simply the length of the marriage and the fact that wife should have transitioned to an ability to support herself, and the fact that my client has children 100% primary in his care, we ask the court terminate support. There's simply just not an ability to pay on an ongoing basis, and I think that based on the case law, my client has paid over half of the length of the marriage. We are asking the court consider an entry of a child support order based on our child support worksheets, which we believe are consistent with my client's income and what wife should be making if she returns to the workforce full time. So we do ask the court adopt our worksheets, enter a child support order, and terminate spousal support moving forward.
All right, thank you. Ms. Menifee, any response?
Yes, Your Honor. First off, William Menifee pays me $1,600 a month, is what agreed to through the court. The $250 is for rent for his parents living on the property that we own together. So that is false. The mortgage that he put in there that he said that he pays, he also put in that he pays, I think, 14 something. And because I'm on the mortgage also, so I know that that is false also. When I left, it was 900 and something. So those are a couple different things there. When I was with him, I was not allowed to work during that time. And while he built his career, what I do is I clean houses through a company. There's 6 other people that work during the daytime. And with the company, how it works is if there's, say, 3 houses in a day, a house can take 2 to 6 hours, depending on size, things that you do at the house. So yes, there is a lot of times that you can't work very full days. I live in Tootle as of right now, because that's all that was available during moving and having to move, because I'm still not getting my half of the house that we own together, because he refuses to finalize the divorce to give me my half of what I am owed with the house. I wouldn't have to be paying over in my rent, which I do pay. My boyfriend that lives here only lives here on the weekends, for the most part, because he works out of town. He works for Weather Guard. So he doesn't pay nearly even, he only pays a little bit towards rent as of where we live. So I pay the substantial amount of the rent. Where else? I'm trying to get my head all together. The lawyer fees of what they're asking for me to pay, I, as you can see, don't even have the money for myself to have a lawyer. or I would have somebody in here with me, let alone to pay for his lawyer. Without the support that I get through him, the 1,600, I don't know how I would pay the bills. Also, with living in Toutle, my point with that is to get the girls to school. 8:15 is the latest I can drop off, or the earliest I can drop off my youngest. And to get them from school, there's only a certain amount of hours I can work within a week, and when they're in school. And that is why I've been with this particular job, to be able to work certain hours during that time frame. He has his mom living on the property as a living at home babysitter for him, for free. I know he says that he pays her. I guess that would be hearsay at that point. But I don't have my mom that lives here. He moved me and the girls away from my family to be away from everybody I was close to when we moved. So I don't have anybody out here for support. And I would love for the divorce to be over, and I would love to get my half of the house. If he could pay me until I get my half of the house, then I think that would be fair. And then that way I can figure out how to pay, and even buy a house and maybe be paying less than what I'm paying right now. I don't know, but this divorce going on for over 4 years because he doesn't want to give me the money that is mine as well, doesn't make any sense at this point.
All right, thank you very much. And I, just for the record, Ms. Murphy, I reviewed everything you filed as well, just so you're aware.
Thank you.
Ms. Gilmore, anything else?
I don't think it's a huge difference, but I just wanted to know for the record, I didn't receive the declarations. I was on vacation, I did look at my email, but I don't believe I received the declarations that were filed on the 13th. I didn't think that has a huge bearing, because it was mainly pertaining to the parenting issues. Just looking, just briefly, my client adamant disputes ever being domestically violent. I think that was fully bore out for the GAO investigation. He complied with the recommendation, did the GP treatment, but again, the history is questionable. My client always supported wife's ability to work and suggested she should be working. I think that looking to the case law in a short-term marriage like this, there's insufficient time to create such a reliance, and I think that my client has supported her for a long enough period. Again, 4 years of an 8-year marriage. My client, and I think that this kind of goes into settlement territory, which is inadmissible, but my client has made every effort to get this case resolved. However, every time that we're close to resolving a case, the parenting plan issue blow up. My client hasn't had the ability to afford to take this case to trial, but needs to do so at this point, because again, every time that we think that she's stable and is going to be able to exercise, a substantial visitation schedule, there's a relapse and the children are damaged in the process. So I agree that this case needs to be resolved, but in the meantime, my client shouldn't be required or tethered to a support obligation that just isn't supported by law.
All right, I appreciate everybody's time and comments. So I'm looking at the temporary family law order that was entered July 9th, 2020. I'm just sort of working off of that. Clearly there's a difference in whom has primary custody of the children, which is something to take into consideration. Second thing the court's going to take into consideration is nearly 3 years of family support has been ordered. Some of that time children were not with mom, not necessarily a significant period of that time, but some of that time. And this is very clearly listed as family support, which is a combination of child support and spousal maintenance. With the children living with father primarily, here's what I'm going to do. The $250 a month for rental income, that will continue. I'm not going to change that at all. So he needs to pay that. I'm also going to ask that or order that everything else in the order besides the $1,600 family support remain. So the Jeep will remain in Miss Menifee's possession and will be paid by the petitioner. Same with any medical, and the insurance should stay the same, home insurance. So the remainder of that order will stay. I do agree case law is a third of the marriage, especially for a short-term marriage that way, to receive full spousal support. I understand that wasn't, this was a combination of child support and spousal support. But I think at this point, I'm going to order that amount end, that we do the $250 a month for the rent on the tiny home. And then all the bills and medical and car remain the same. So those will be continued to be paid by Mr. Menifee. I'm not going to award any attorney's fees. And I will sign that order upon presentation.
Does the court want to set a presentation date?
I'm happy to do that. We can do a Friday morning, or the next Tuesday, I think, is either the 11th or 18th of July.
What is that for? I'm sorry.
To enter the order for the ruling that was made.
The 11th works for me.
Are you available, Miss Menifee, on July 11th?
So I'm sorry, I'm not trying to sound unintelligent here. On July 11th, you'll be entering what you just said. And so we'll have to come back to court to finalize that.
Yes, and that's not an unintelligent question. I wonder about it all the time. It's usually if there's anything that you disagree with in that order, if Miss Gilmore sends you that order and you're like, yeah, that's what the judge says, and you sign off on it, then she can submit that and you don't have to appear on the 11th.
Now, as for, I understand he wouldn't, after the 11th, he wouldn't have to pay the money anymore, or the $1,600 anymore. Is there, since he's living in the house that we own together and he's not giving me my half of it, can he pay me rent for the house?
No, that's not how that works. So he's keeping it in good working order. If it's ultimately ordered that the house be sold, then you would benefit from whatever the sale of that house is. But if he's maintaining the home and living in the home and paying the insurance on the home, he doesn't pay I wouldn't require you to pay him rent if you were in the primary home and he was living in an apartment. So
as Megan was saying, Miss Gilmore was saying, I should have somehow gotten him to sell the house. I'm not sure how I'm supposed to do that to finalize this divorce.
I don't know what you're referring to, but if that's what your want is, then I would encourage you, because you're representing yourself, you're more than you're completely allowed to reach out to Ms. Gilmore and talk about what you would want to get this taken care of. So you can have those kind of conversations with Ms. Gilmore on your own behalf, because you're representing yourself. So there's nothing that says you can't call her up and say, okay, this is what I think is reasonable. What does he say about that?
And then do we have to have a whole separate court? I tried to get some paperwork into the court office to be able to add the children onto this. And apparently the paperwork that I got I filled out, was all the incorrect paperwork, because all your paperwork is very confusing. It's been a month and a half since I've seen them. We had been 50-50. He put in there that he had sole custody, but we've had 50-50 this whole time. My daughter's birthday is on the 2nd, and she's been begging to see me. I'm sorry.
No, I understand that. I don't, Miss Gilmore, if you want to weigh in, I can't give you advice from the bench. I will tell you that there is a legal aid clinic. So there's attorneys that are here in the courthouse on Mondays. Miss Wade, can you confirm that for me? I think it's Mondays from like
From noon to 2.
noon to 2 on Mondays. And I know we've had a couple Monday holidays recently, but they're here every Monday from 12 to 2. It'll help people fill out paperwork, make sure you have the right paperwork for what you want. Miss Gilmore?
I'll speak with my client about some sort of conflict of participation in hopes of avoiding further motions. I can't guarantee anything. Well, I'll talk to them.
Okay. All right, and we'll set it for the 11th of July at 1 o'clock for presentation. If the order is agreed, then we can strike and parties don't have to appear.
Thank you.
All right, thank you. Good luck.
Your Honor, number 4, this is Megan Gilmore. That's on for presentation, fee matter.
Is that a case that you then need set with Judge Fassett?
We presented proposed orders on June 30th. I haven't received any objection to those orders. However, Mother is pro se. So I would simply ask the court to request if she does have objections. If so, then yes, we need to set it over.
Okay. So do we have Kimberly Menifee online?
Yes, Your Honor. Can you hear me?
Yes, I can. Have you received the proposed order from Ms. Gilmore?
I did get the proposed order, and as my understanding, when they said what was proposed, that wasn't supposed to be signed until today. And he didn't pay me on the 1st, and so I'm now back on my rent right now because I had believed that this wasn't being signed till today. And I didn't have adequate time to be able to figure out the money to be able to pay my rent without that money. So if the judge decides that he doesn't have to pay me the $1,600 anymore, is what I believe that they sent me. Just like what the judge said in the courtroom, then, I mean, there's not much I can do about that. But as for taking that money away before it's signed, I don't think that that's appropriate, due to I wouldn't have had enough money to figure out how to pay my rent when I rely on that money for.
Okay. So I think it sounds to me, and correct me if I'm wrong, ma'am, the only disagreement you have with Ms. Gilmore's proposed order is you are unclear about whether the judge's ruling ended the $1,600 of support on the date of the hearing, which looks like was June 20th, or whether it was supposed to continue until the order was signed today. Is that correct?
Yeah, because my understanding would be it's not done until it's signed.
Ms. Gilmore, I'm looking at the court's notes on that. It doesn't state an end date, but my assumption is it ended on the hearing date. But do you have any more information?
I was looking at the minutes to see if I could recall. I think it just wasn't addressed by the court. We likely would need a court to get a standing from Judge Fassett on when her termination date was.
Yeah. So let's do this because I do think that it sounds like that is a somewhat significant issue for Ms. Menifee and her finances. So let's set this over 2 weeks to July 25th at 1 o'clock. And the parties can address the clarification with Judge Fassett at that time.
So that would still leave me on not being able to pay rent that was due on the 1st, when it would have been, I normally would have gotten that money, and today would be the day to sign for it.
Mm-hmm.
And so, and I mean, I don't want to lose the place that I'm staying in.
Right. Yeah, this is there any way we could squeak them on just for this to next week?
believe so. I think it's closed, but we would have to. You can ask them for administration.
Okay, yeah, I think just on this issue, and I think it's going to be a fairly short matter. I'm just going to put in a special request to move you guys just 1 week over. If Ms. Gilmore, does that work for you?
Yes, that works. And I can also just email Judge Bassett and see if she can get some input to us in the interim. And I'll do Ms. Menifee.
Okay, so let's just, because this issue should be short and I understand the financial implications to Ms. Menifee, let's set this over 1 week to July 18 at 1 o'clock. But because that docket is closed, Ms. Gilmore, if you're able to get a response via communication with the court, that probably would be in everyone's best interest.
So as for that, we'll have a second, I'm not trying to repeat anything, but we'll have a second one on the July 18th.
If so, Ms. Menifee, here's what I would say: plan to log back in to this same Zoom link next Tuesday, July 18th at 1 o'clock. If this issue gets clarified before then, Ms. Gilmore will reach out to you.
So then would that, at that point, everything would be signed, it's just saying that he doesn't have to pay me the $1,600 anymore.
I'm not making a ruling on that. Judge Bassett is the one who made the ruling on the support terminating. We're gonna get clarification from her about what the end date of that was supposed to be. So
Okay.
plan, unless you hear otherwise, plan to log in on July 18th at 1 o'clock.
Okay,
Okay,
thank you.
all right, thank you.
Right. Any other strikes or set overs?
I have a set over, but Ms. Beagles doesn't look like she's online yet. But I do have a very short matter on number 5, Menifee and Menifee.
All right, Menifee and Menifee is 20-3-00227008 on for order, signing of order. I didn't see, I know that there was a question from, do we have Miss Menifee present?
Yes, I'm here.
Okay, so I know there was a question last time about the start date, or the end date, excuse me, of the support. But I didn't receive any other written objections, and should I have Miss Gilmore an order in my stack here?
You should. The only complication would potentially be is if it was destroyed after the last hearing in front of Commissioner. If not, I can present another order.
All right, I don't see one in this stack. I know that I reviewed the proposed order that was filed back at the end of June. And I reviewed the hearings, the previous hearings, and feel that that order does comply with the court's order. So I will sign off on that order once presented.
Your Honor, this is the clerk.
Sure.
We just handed you that order.
So
I put it in the stack here. I don't see Menifee. Let me double check.
Your Honor, it was paper clipped behind the other order.
So it's paper clipped to a different order?
Yes.
All right. I see it was behind another order. So I do have that, Ms. Gilmore, so I will sign off on that.
Thank you.
Right.
So, Your Honor, this is Miss Menifee. So my understanding was nothing was done until we did the court date, which was on the 11th. And so I didn't have nearly enough time to be able to figure out changing my finances completely to be able to pay rent. So I'm currently back on my rent right now because I thought that I had at least that one last payment of the first before the court date of when we're supposed to actually sign and come to the agreement on this.
Well, I think I made the ruling back in June that that there'd be no more payments. So,
But it wasn't signed until we had the court date. And
I understand that, but it's essentially effective as of the court's ruling. So I will enter that order as proposed, hearing or not receiving any objections other than the clarification that I think we dealt with last hearing. All right, thank you.
That was the final hearing in their divorce. Mom did not return to court to try and reestablish her visitation, even though she submitted a copy of her AA attendance to the court prior to the hearing in June where the judge terminated the family support. It took 9 months from the last hearing for them to finalize their divorce and put a final parenting plan in place. I assume that since they did not come back in front of a judge, that they were able to come to an agreement with the help of Dad's lawyer. I would expect that as long as Mom can show that she's clean, that her visitation would have been reinstated in some form. I'm not sure if they went with supervised visitation or not, but whatever was put in place must have been agreeable to Mom since she didn't protest.